On this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
As always, appreciate you coming on to the program, and let's get right to it. And first off, this is a case that comes right here in Kansas, a recent opinion by the Kansas Court of Appeals. It is an explanation concerning a nuisance case, in this case, a major hog nuisance case, looking at the explanation of property rights with respect to road ditch rights of way, and this as well as the common law of trespass and nuisance, in addition to the Kansas right to farm law. And this is an interesting case, but a very a decision on a case of extreme nuisance with regards to agriculture.
Mm-hmm. Yeah, Greg, I think this is probably the worst, most egregious ag nuisance case I've ever seen, particularly concerning what I'm referring to as the conduct of the individual involved here that created the problem. This has been a long-standing problem out in Norton and Phillips counties. The farming operation kind of straddles the county lines, but this is on appeal. It came from the district court in Phillips County. And what you had here was an individual that inherited basically multiple farming operations and installed about 2 miles of pipeline in the road ditch right-of-way next to a public road to transport liquefied hog waste to spread on his crop field. So if you can imagine in your mind here, I try to draw a picture for people listening in this morning, is that you've got this a large farming operation. They start a hog facility, and he's got a farm field about 2 miles down the road where he has to pass a couple of neighbors that own farmland in between he and this crop field, and he wants to put his hog manure on that crop field. Now, he does have another field that he could have applied the manure to that doesn't have any neighbors that live nearby, but he chose not to do that for various reasons. He needed it on this field, apparently. But one of the neighbors has a house across from this field. And keep in mind, the neighbors own the land next to the road along these 2 miles that he has to traverse down the road to get to that field. And so he comes up with this bright idea that he could just co-opt the ditch right away of his neighbors and lay 3 pipelines, 2 to carry water to his facility and 1 to carry the hog effluent, the waste, back to that field. So trekking, picture in your mind, his idea is to dig up the ditch road right-of-way for 2 miles from his hog facility to get to his field, where he's got pivot irrigation arm in that field. He wants to hook that line into the pivot irrigation and spray it on that field, and also use an end hose that's on the pivot. So hopefully you got a picture in your mind of what he's doing. Now, a neighbor has a home across from this field and across from that pivot irrigation arm that's going to spray the hog waste on the field. Okay, so that's your setup. And he didn't get the neighbor's permission to lay those pipelines in the ditch road right away. He didn't get the county's permission, either Norton or Phillips County. And he tried to lobby the legislature, and that failed in committee. And so he just decided, I'm just going to go ahead and do this myself. Well, that stirs up the county attorney. The county attorney tells him, no, you can't do this. You have to get permission of the landowners that own the land adjacent to the road and own the road ditch. You've got to get their permission. Well, the Court of Appeals indicates that he kind of misled the Board of Commissioners into thinking that he had gotten permission. Still never signed any of the permits, never filled out any of the permits and before he started this project. Starts in on the project. The county attorney sends the sheriff out to stop him. He temporarily stops, sends his daughter-in-law back to the commission, and she fills out the paperwork, but the county never signs it. And he then goes ahead and completes the project. By the time the sheriff got out to him, the court leads me to believe that he was a long way through the process of putting these lines in. So he stopped temporarily, daughter fills out the paperwork. County never signed off on it. He goes ahead and finishes the project and creates an absolute disaster for the neighbors.
You know, you just laid out that scenario, and just thinking about it, and then it happening as he did in this case. Well, there's a lot of ways to go with this. Let me just say that first. But the appellate court definitely affirmed, and in doing so, definitely hammered home some points relative to all farming operations in this case, too.
Yeah. Well, this goes to a jury trial before we get to the Court of Appeals, and the jury returned a verdict against him of over $100,000. It was $126,720 in property damages for the plaintiffs, plus $2,000 in nuisance damages, plus $50,000 of punitive damages that were added on to punish him. Now, those are rare, but the court did that. And it goes to the Court of Appeals. The Court of Appeals looks at this, and they affirm everything. And some of the bad things, I said just a moment ago that he created a mess for the neighbor. Well, he's spraying the hog waste within 200 feet of the neighbor's home. The spray drift, the court says, covers their home. Their home has been covered with flies. The wife of one of the couples, there were two couples that these adjacent owners that were involved in this case. The wife, the court said, got sprayed with the hog waste personally, and so they have another home in Nebraska. So she just moved to Nebraska, and the court said she'd never stayed at the Kansas place within the past year. Couldn't take it. And this farm family was also wanting to sell some of their farmland to their existing farm tenant. And he said, no way. That deal fell through because of the odor issue. It was so bad. And this just created a massive problem. And then the court said, after the neighbors sued on a nuisance theory, that the farmer went ahead and, for a while, doubled the amount of waste that he pumped through the pivot irrigation and dumped truckloads of manure across from their home in his field. And the court said this is willful. This is just horrible behavior, and that's what led to the punitive damages being issued because he did this deliberately and willfully. And he always maintained, well, I can do what I want to do with respect to that road ditch because the public owns the road ditch. Well, Greg, when it gets to the Court of Appeals said, well, the trial court got this right. And here's where we get to the key points that I think are important for all farmers. The court issued a very, very thorough opinion. I think this absolutely forecloses any chance that this fellow might have if he thinks of taking this to the Supreme Court in Kansas, and I don't think the court would take it anyway based on this opinion. They locked this thing down pretty tight. They said, look, the individual, and this is the key point here. A lot of people, I've gotten this question over the years, and I'm glad the court answered this. This is what I'd always said on this, because this goes back many, many decades. We could get into the 1800s on this in terms of who owns the road ditch right-of-way. And the court said each adjacent landowner along a public road owns that ditch, and all that the public has is an easement over that to travel the road. That's all it is. And since you own the ditch, the owner of that land can do what they want in that ditch as long as it doesn't interfere with the right of the public to travel on the adjacent roadway. So we can, to an extent, we can mow that. In the country, we can hay that. As long as we're not interfering with traffic flow, we can do those things. But for somebody else to co-opt my property and think they can run pipelines through there, as the court said, these were absurd arguments. And I almost get the impression the court was close to sanctioning the attorney for bringing these arguments, because they said multiple times, this argument is absurd. There's no basis in Kansas law for this. So that's the first point, Greg, and that for farm families to understand is you own the road ditch right away, and the public has an easement over it. And so a public utility, for example, can put a gas line through there. You can have rural water lines come through there. You could have a telephone line or some fiber optic cable come through the ditch. But you can't just use that for your own individual private purpose, which is what he was doing here. And Greg, he even made the argument that he had a public purpose because he was raising pork products that the public would eat. And the court, you get the impression that the judges were just rolling their eyes at some of these arguments, and they said, there's no end to that argument. You have a purely private purpose here. There's no public purpose, which is what you need. And if you don't have that, the court said you have to get the landowner's permission to use their ditch, the right of way, which they own, and you didn't get their permission. You didn't get the permission from the county, and the legislature didn't do anything to allow you to do this. So you are trespassing. And that's the first key point that people need to understand coming out of this case.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, joins us on the program this morning. And we've been talking about the major hog nuisance case here in the state of Kansas. And Roger, one more point I know you wanted to talk about, but this is also the fact that this gentleman was also trespassing, excuse me, as well. But this has to do with the right to farm law with regards to trespassing.
Yeah, that's right. He tried to raise the right to farm law as an escape hatch, saying you can't sue me for nuisance because of the Kansas right to farm law. Well, the Kansas right to farm law, two things here. One, the court didn't talk about. They missed this argument, and that is it doesn't apply when a farmer is suing another farmer. We have a court opinion in Kansas on that. That never came up. But he still lost. He couldn't use the right to farm law to protect his conduct because that only applies if your farming operation is in compliance with all federal and state laws, rules, and regulations. Well, he made kind of a novel argument. Again, the court said it was absurd that the common law of trespass was not included in what the right to farm law said you had to be in compliance with. In other words, common law was not part of state law as defined by the right to farm law. The court said, come on, you can't carve the common law part of the state out. That is part of state law. And so since his nuisance was created by his trespass activity, the right to farm law did not apply, and he couldn't use that to immunize his conduct. And that's another key point, very significant point coming out of this case.
All right, another big issue that came out last week was the EPA as they issued their finalized amendments on the existing WOTUS Rule. This, of course, having to go back in association with the Supreme Court's decision on Sackett v. EPA as well. But from your perspective, what were some of the fine points that we saw in the revised WOTUS Rule?
Well, they did the two things they had to do. They removed the significant nexus test that allowed streams and wetlands adjacent to larger water bodies to be jurisdictional under the Clean Water Act. The U.S. Supreme Court in Sackett unanimously rejected the significant nexus test. And I want to emphasize that. Well, very rarely, Greg, do we get a major environmental case where the Supreme Court is unanimous. But here they were. They were unanimous in saying that significant nexus test is no good. So clearly the EPA had to remove that out of that final rule they put out in March of this year. And secondly, they had to also do what the Supreme Court said on this point, and they had to limit jurisdiction over wetlands to those that are relatively permanent and have a continuous service connection to navigable waterways. So wetlands, which would share a surface water connection with a WOTUS, but no longer have that connection because of some man-made barrier like a levee, a dike, or a sand dune, won't be included in the definition of a WOTUS. Now, that's all good and fine, but I think many questions are left unanswered, particularly the nuts and bolts issues about the definition of what is a ditch and other farm features that are filled with water only sometimes, the ephemeral streams, for example. That's a big issue, particularly out in western Kansas. So, the dirt's in the details on this. Yeah, they did the big issue items that they had to do because of what the Supreme Court said. But I always worry about EPA, and what are they going to do here, kind of to backdoor retain their jurisdiction, even though they're saying in the front door that we've complied with the U.S. Supreme Court's opinion. So I would anticipate, Greg, that once they start implementing this, it may not be implemented the way that the Supreme Court indicated that the rule should be, and we'll end up with more litigation. I fear that. I hope not, but that's my fear.
Did they, or when this was issued as well, normally if you're going to issue a ruling like that, there's the public comment period that
Right.
you are supposed to have, but in this case, or they had it as a specific case where they did not have to do that?
They didn't. None of us got a chance to see the rule before it came out on the 29th of August. There is an exception for good cause to the notice and comment requirement of the Administrative Procedure Act, and they used that because they said, well, the update was sufficiently urgent. Again, I think that's being a bit of a sneak here. But there is that exception that is in the Administrative Procedure Act for good cause. And that's what they did. And so they just put it out, and the rule is final, and it became final as soon as they became effective as soon as they issued it on the 29th of August. Now, they do say that they're going to hold some hearings. The first one's going to start on the 12th of September, I believe, hearings to take input kind of after the fact. But I wonder what good that's going to be.
Yeah. Just to emphasize again, after the fact, that when they have the hearings, is that in this case as well, this is, and this may be not the right term, but immediate implementation?
Mm-hmm. Yeah, effective immediately. So it became effective on the 29th of August.
Okay. Roger, before we go, of course, the Kansas State Fair starts this Saturday, or Friday, but of course the big first day will be on Saturday. Mm-hmm. But you will also be down, not this coming weekend, but not too far after that.
Yeah, on Friday the 15th, I'll be speaking from 10 to noon. I'm not sure which building it's in, but I will post that. I've got information. I just failed to look at it this morning in terms of where I'm at, but I'll get that posted. I'll probably put something on Facebook about that too, so people can see that. But it's a 2-hour seminar on estate planning and charitable giving, and it'd be good for anyone interested in those topics to a good 2-hour session for them at the State Fair.
All right, and they can go to your blog to find out more about that as well.
Blog, Facebook, Twitter. It'll be on my website and my CPE calendar. I'll list it there too, and that should show the building that I'll be in on the 15th from 10 to noon.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.